Thank you, everybody, for coming. This is the March meeting. Judge Delano is here to talk about the proposed local rule amendments. So without further ado, here she is.
All right, great. Thank you, Paul, and I'm sorry to keep you all waiting. I got stuck in a hearing. I think maybe a few people are here from that hearing. So that means I was stuck in a hearing and I didn't have a chance to review my notes and I'm out of breath. So thank you, Adrian, for videotaping this. It's always a pleasure. Okay. As you all, I think, know, I'm the judicial liaison for the Local Rules Attorneys Advisory Committee, which means that when I got involved a couple of years ago, I completely hijacked the committee. And it's wonderful. I am a megalomaniac, and it's been a lot of fun. That is not to diminish the role of the committee at all. The committee is just incredible in terms of coming up with helpful suggestions and good ideas, and it's very easy, you know, if you just sat down with our local rules one day and started trying to figure out what you would do if you were king of the bankruptcy court and what kind of rules you'd like to have. It's really great to have some cross-checking with some people that are in the trenches every day, and so they've really been great. Greg Champeau is on the committee here from Fort Myers. Other committee members are Laura Fernandez, Donald Kirk in Tampa, Betsy Cox in Jacksonville, and Rick Weber in Orlando, and they've really been great. And Raymond Waxpack, I don't know if y'all have any much involvement with him, and I forget his formal title, Chief Operations Officer or something like that, but he's our clerk's office representative on the committee, which is really fabulous because he is able to really tell us you know, what needs to be done from a clerk's office perspective. So there's a lot of revisions that go that way. So it's been really, really, really helpful. This year is really a complete revamp of a lot of our local rules. And I sat down one day, I'm embarrassed to say that I've been doing local rules now for 3 years, and I never sat down with the local rules and read them all start to finish. And when I read them all start to finish, I was kind of horrified because a lot of the local rules were completely superseded by current practice, particularly by CMECF. And there were some fixes that had been put in to take care of some CMECF issues, but they weren't global, and there were a lot of rules that were still current local rules that really had no relevance to today's practice. So the rules are posted on the court's website along with this summary sheet. The summary sheet actually is hyperlinked to each of the local rules, so you can take a chance to look at it. And maybe if you want to mark those that you might be interested in going and spending a few moments with, that would be really helpful. But they're posted on the court's website for public comment. It's a 45-day public comment period. That period expires on April 24th. I welcome your comments. I welcome your careful proofreading. I welcome, you know, any moment of your time that you can spend or that you have to spare on local rules, and giving us your input is just really, really helpful. What happens once we've gathered all the comments is I have another meeting with the committee. We review the comments, decide if any revisions are appropriate, take them up with the judges at a judges meeting in May, get final approval from the judges. The rules will then be posted hopefully right around June 1st with an effective date of July 1st. So I'm just going to kind of run through these, and I'll give you a little of the backstory on some of them. Some I will mention to you. I'm particularly interested in the public comment and what the committee and I may have been missing, and the judges when we have gone through making our recommendations regarding revisions. First, Rule 1001-2, Case Management Electronic Filing System. You all know that you are required to maintain original signatures for 4 years until 4 years after the case is closed. That 4-year period is being reduced to 2 years. One of the things we found out in discussing this with the committee was that there were certain large law firms in Tampa that thought that a scanned-in version of the original signature would suffice. No, it does not suffice. You need to have the original signature, the original hard copy. As a practical matter, that has only become an issue in, I would say, 2 or 3 cases that I am aware of, and it's been in situations where attorneys had affixed electronic signatures or scanned signatures to bankruptcy petitions or bankruptcy schedules, and the client said, I never filed that, or I never signed that, I never reviewed that, I never gave my lawyer the authority to sign this for me. And the reason why that is important is because the reason why it's important to have the originals is so crucial is because if it ever came down to it, if a handwriting expert needs to see the originals, a scanned-in copy just won't do it. Yes, Mr. Hollander.
Do you need to keep the entire document or just?
I think just the signature page is fine.
Page?
Yeah, I think as long as you keep the signature page, it's fine. As a practical matter, if you're being particularly, what's the word I want to use? Not paranoid, vigilant. as a practical matter, you might want to have it all attached, but anybody could reaffix something, so I think as long as you have the original signature page, that's all that you're required to keep. You're not required to keep the whole original document, but this has never been a problem with a mainstream, and it's never been a creditor's issue. It's always been a consumer debtor issue. It's never been a problem with the mainstream consumer debtor bar. It has been a problem with some outliers. The outliers that I'm aware of are no longer practicing bankruptcy law, so it's really not a significant difference. But the good news is you only have to keep them for 2 years and not 4 years. So I think everybody will be in favor of that. The big change, and this is something that I am interested in comments from counsel to see what the cons are, because I can tell you all the pros. But the big change is, instead of scanning in a document for filing, a paper for filing, and then uploading it, we want you to convert the document to a PDF. You have that little button on your computer, convert it to a PDF. So, as a practical matter, there are a number of reasons why this is beneficial to you and beneficial to us. It's beneficial to you because your work looks so much more professional when it's been converted to a PDF document. And I could, someday maybe I will, I'll take examples of scanned-in documents and converted documents. And the converted documents, the screen is white, the type is black, it's nice and clear, it just looks so professional. The scanned-in documents, the screen is gray, the type is a little darker color gray. It doesn't make the same impact. Sometimes the page gets scanned in a little crooked, then it's got to, switch your eyes, around. It looks so much more professional. The other advantage is that it takes much less room on the court server. A converted document takes much less room on the court server than a scanned-in document does. And the other advantage is that the scanned-in documents are text searchable. So you can, Control F, search for any term in the document, and you can find it right away. So this is something that the judges, I think, feel fairly strongly about. If there's a problem with it, then you need to make a comment so that we can evaluate those comments and make a decision. Greg, you have a comment?
One of the things that we had talked about previously is sometimes when you're doing a verified motion, where you need the debtor's signature on it, should we just move it to S/S now?
You just move it to /S/S. You keep your original, okay, which you need to keep anyway, and you can attach it as a separate page. And of course, to the extent that you're attaching exhibits or documents that you only have in paper form, those, of course, you're going to scan in as usual. But anytime you are creating a Word perfect document, I assume you all have, Adobe PDF. You just click on that Adobe PDF link and then it's saved and that takes care of it. So I hope that will not be a problem. Yes, Louise.
Does this apply to petitions and schedules prepared through, Best Case?
Right, you should be able to just upload them straight through Best Case. You look at Best Case schedules that are, uploaded that way, they're works of beauty. They're so easy to read. You look at them that have been scanned in, they give me a headache working with them. So yes, they'll be much easier for people to work with. So anyway, anybody has a problem with that, please make your comments because that is something that will be considered.
What about like client verifications or affidavits?
You can do the S/S.
You can, as long as you keep the original.
As long as you keep the original. Right. Yes.
The only issue, and it's not really a concern, but something that everybody may want to think about is when you convert to the PDF via the software, all the metadata comes over, or probably comes over. whereas if you scan it in, it doesn't.
That
So
is-
there's an e-discovery issue
Right.
there somewhere.
Yes, and that is something you need to give a little thought to. I think when you create the PDF, I don't think the metadata comes through. Okay? You think it does?
No, it does
No,
not.
I do not think it does. Something that you all have to be careful about, and this is something that we'll get to in a moment on a discovery issue, is that if you, like if you circulate a document in Word, you're emailing settlement negotiations back and forth. If you haven't scrubbed the metadata off or cut and pasted your settlement communication into another letter that's then clean, you are sharing metadata. And so someone might see, you convey a $100,000 settlement offer, and somebody, I think it's in violation of Florida ethics rules, but somebody clicks on the metadata and sees that their first draft offered $150,000. You don't want to be sharing that information. That's something that everybody has to be really careful about. But I don't believe when it's converted to a PDF originally that the metadata gets included with it.
There's a good program by paying for the metadata discovery you can add onto your email that automatically, as you transmit anything with an attachment, will stop and say, do you want to? It's not that expensive, and it's really
That's a good.
P-A-Y-N-E.
That's a good hint. That's a very good hint. Okay, 1009-1, amendments to lists and schedules. You all know, consumer debtors know particularly, when you file an amended list of creditors, schedule, what are they? F and, I just forgot, E and F, I can't remember. Okay, when you file that amended schedule, if it, unless you manage to get it in right before the notice of commencement has gone out, you need to serve the creditor with a notice of commencement and all that stuff. The list of things that you need to serve upon the creditor is now being increased to add the notice of deadline to file proof of claim if there has been one. So let's say, for example, there's a bankruptcy case, the trustee serves a notice of deadline to file proof of claim. 2 days later, within that, well in advance of the claims bar deadline, you amend and add, 10 additional unsecured creditors. You really want them to get that. You really want them to have notice of that deadline so that they get the proofs of claim on file and you don't have other complications in your bankruptcy case. So that's just one more thing that you have to add to the list of documents that have to be served to any newly listed creditor. And really, it's just one more document. And obviously, if there has been no notice of deadline to file a proof of claim, then there is nothing additional to serve. So that's not too hard. 1073-1, assignment of cases. This really doesn't affect you all or Tampa really that much, but there was an amendment to the divisional, the rule that governed the divisional breakdowns. And basically what it did was it removed Volusia County from Orlando and sent it to Jacksonville, I think, or vice versa. I can't remember which. In any event, there were a number of attorneys that were filing. I think what it did was it just sort of incorporated the actual practice. And the attorneys that are in Volusia County were closer to Jacksonville, or they were closer to Orlando, one or the other, and they were filing in the division that was closest to them, and so the court finally just kind of recognized that. One of the issues comes up when you have successive bankruptcy filings. So our rule is that if a debtor has one filing assigned to one judge, let's just use Tampa, for example, since you have many judges. So if you have a case that's assigned to Judge Williamson in Tampa, the debtor files another case, it gets assigned to Judge Williamson in Tampa. The question is, what happens if there's a cross-divisional successive filing? So a debtor files in Tampa and then a debtor files in Fort Myers, okay? Well, under the old rule, the Fort Myers case would have gotten sent back to a Tampa judge. Under the new rule, the case stays in the division where it's been filed, and if it's important to somebody to have it transferred back to the prior judge, then anybody can file a motion to reassign the case to another judge. So that shouldn't affect most cases. You really kind of see it primarily Tampa, or maybe a little bit here between Sarasota County that would otherwise be filed in Tampa. But I usually see it like in Polk County. There are people in Polk County, they live and work closer to Orlando than they do in Tampa, that kind of thing. So that shouldn't be too hard. Corporations and other non-individual persons. I got such a kick out of this rule because when I was looking at it, it was titled Corporations and Other Non-Natural Persons. Non-natural. What? We have unnatural people in the bankruptcy court? I was stunned. So anyway, we kind of have reworded it, and the court has had, really all the judges have had a practice, although corporations are required to hire an attorney in small matters when the corporate representative shows up. We're willing to listen to the corporate representative. So a corporation does not need to hire an attorney to file a proof of claim, to attend a 341 meeting, or to examine the debtor at a 341 examination. And if an objection to a claim is filed and the corporate representative shows up, we're going to listen to them. Now, if it ends up being a big hairy trial, yes, we're probably going to say they've got to get a lawyer. But for just routine kind of bankruptcy administration type of issues, we are willing to have the corporate representative appear. So that rule has been amended just to clarify what really is the current practice. 2015-1 trustee expenditures. This came out of a suggestion from Diane Jensen. Thank you very much. So what happens is sometimes a debtor wants to appear forma pauperis without paying a filing fee, and the debtor qualifies. But it turns out the debtor has some assets. So what Diane would do when she recovered some assets is she would file a motion for permission to pay the filing fee. And the question came up, why does she have to file that motion? Can't we just let the trustees pay filing fees under those circumstances? And the answer is yes. And that's a benefit to the court, because the court collects the filing fee, obviously a benefit to the trustee, because the trustee gets paid the $60. So that works out well for everybody. So that's just saving the trustee from having to file that supplemental motion. 2016-1 compensation of professionals. This is particularly in the Chapter 11 arena. And you probably know that when you file a fee application in a Chapter 11, we have what we have been calling the fee application cover page. And so a question arose when we added Chapter 11 fee applications to the negative notice list. Some attorneys were putting the negative notice legend on the second page of the motion because they had been told that the first page had to be the cover page. So big confusion. So we wanted to clarify that. The negative notice legend always goes on the first page of the motion, or of the application. And then just to make it clear, we're not going to call the fee application cover page a cover page anymore. We're going to call it a summary. So that way there shouldn't be that question when people look at those two rules. That one's pretty easy. Appearances by law students, this really won't affect you, but this is particularly with schools that have clinics and they have law students that are working under the guidance of a supervising attorney. And we had a provision in the rule that is really a fairly recent rule, but this didn't raise any eyebrows when we adopted the rule maybe 2 years ago or so. But the rule had required qualified law students to comply with applicable requirements promulgated by the Florida Supreme Court and the Florida Bar, only nobody knew what those were. So we decided, let's just take that out. So that makes it a little bit simpler. Another Chapter 11 issue, 3018-1 on ballots. We now have a form of ballot tabulation that we would like everyone to use. It'll be posted on the court's website. It's attached to the draft of the rule that is posted on the court's website now. And what we were finding in Chapter 11 cases was that a lot of the ballot tabulations we were seeing, first of all, no two ballot tabulations, no two attorneys or law firms prepared their ballot tabulations the same, and we couldn't tell what was going on. So this is just makes it a lot clearer, and if you follow that format, it'll be easier for everybody in getting ready for confirmation hearings. Applications for administrative expenses in Chapter 11, 12, and 13 cases. I think the rule was that they had to be filed 14 days in advance of the confirmation hearing, and that just got backed up to 21 days. Reaffirmation agreements. I think when we were here last time, I think I mentioned, and I know Judge Jenneman mentioned in her State of the District address, that now we had reaffirmation procedures. So I thought, well, I'll go on the court's website and I'll find those reaffirmation procedures. I couldn't find them anywhere, okay? Well, I'll tell you where they are. When you can't find something, if you look at email blast notifications, it's on as you're looking on the screen, it's on the lower right-hand column there. If you look at email blast notifications, you can scroll down and they're listed by subject matter and find it. And that's where I found the reaffirmation procedures. the reaffirmation procedures that are posted on the website at that location pretty much are internal procedures in terms of telling you how the clerk's office is going to process reaffirmation agreements. Those procedures have now been incorporated into a local rule, so you won't have to search for them under the email blast notifications. And basically, it's nothing too different, but some of you might have noticed a little hiccup in our system a few months ago when I had a number of reaffirmation agreements set where attorneys had signed the reaffirmation agreements, but they had checked the box that a presumption of undue hardship arose. And judges throughout the country have hearings on those all the time. What we're trying to do to streamline clerk's office operations is to let the case managers process cases and process reaffirmation agreements specifically the same for each judge. So some judges would say, I want to set those for hearing. Other judges say, I want to take a look at them. Generally, my feeling is that if an attorney has signed off on the reaffirmation agreement, even if the undue hardship box has been checked, I'm not going to set it for hearing. I did have a series of hearings a month or two ago, including one debtor who was upside down on her income and expenses by $5. I felt terrible that the attorney had to come to court because, you know, there was a $5 discrepancy there. The other thing that has been added to this rule, just a little bit of a comfort provision in the rule for the benefit of attorneys. Let me see if I can find it really quickly. Is paragraph H of the rule, no presumption of enforceability. The court's approval of a reaffirmation agreement shall not constitute a presumption that the terms of the reaffirmation agreement are enforceable against the debtor. We just approve them. Whether they've actually complied with 524 or not, we're not proofreading every line to make sure it's accurate. And I think that probably should give attorneys a little comfort who had some concern that perhaps by signing on a reaffirmation agreement, they were saying that that the debtor was going to be able to comply with the reaffirmation agreement. Yes, Greg?
Judge, doesn't the new procedures also speak to recording of the reaffirmation agreement after the discharge if the parties
Yes, it
have a
does.
mutual agreement
Yes, it does.
beforehand?
This is the nightmare that we face all the time. Debtor has been discharged, and then suddenly a reaffirmation agreement comes in. Debtor's attorney files a motion to vacate the discharge, and there's no basis under the code to vacate for the debtor to vacate the discharge in order to enter into the reaffirmation agreement. So we have a provision now, paragraph F, the parties must agree to reaffirm debts prior to entry of discharge. So absent extraordinary circumstances, because there are always extraordinary circumstances, the court will not set aside discharges to consider untimely agreements to reaffirm a debt and will not set hearings on reaffirmations made after entry of the discharge. However, the court will consider reaffirmation agreements made before the entry of the discharge, even if the written agreement is filed after entry of the discharge. So if there was a meeting of the minds in advance and it just didn't get filed, that takes care of it. But basically, we're not going to be setting aside discharge orders. And how many creditors lawyers do I have here? Oh, good. Oh, well, you haven't heard this from me, Louise. You know, if somebody, is it enforceable if it was entered after the discharge? I don't know. If it makes the creditor happy to have it on file, great. Okay. It's just fine with me. As long as they're happy, that's great. Okay. Filing papers. This is a little confusing. 5005-1. We had rules 5005-1, 5005-2, 5005-3. They didn't really comply with the whole CMECF, and so this is just they're all sort of combined in 5005-1, and you can look at the current rules to see what happened. If anybody wants to see a red line, they can, but we kind of struck, working through this with the committee, just kind of struck everything that wasn't irrelevant and then put it under 5005-1. Withdrawal of the reference, those are stylistic changes, just makes it a little easier to read. Courtroom decorum, 5072-1, we added a new section that directs the parties to the court's policies and procedures on telephonic appearances, which is posted on the website. You can find that. 7005-1, proof of service in adversary proceedings and contested matters. So, what was old 7005-1, most of the provisions are now in 9013-1. So essentially there's two rules governing proof of service. Proof of service in adversary proceedings and contested matters, and proof of service in the main case. So in 7005-1, hold on while I pull that one up, make sure I have it right. Okay, 7005-1, adversary proceedings and contested matters. When all the parties are represented by counsel, there's no need to keep filing proofs of service that you've served them with something that they've already gotten by CMECF notification. So as you know, when you get an order now from the court, it'll say at the bottom who is directed to serve and file a proof of service. When it's in the main case and it's being served on creditors, yes, it needs to be served. But when it's in an adversary proceeding, you have a plaintiff and a defendant or multiple defendants. If everybody is represented by counsel, everybody got the order when it hit the docket. The attorney doesn't need to then turn around within 3 days and file a proof of service that says that everybody got it by CMECF. That's just multiplication of filings. That don't make any sense. So that's the adversary and contested matters, and again, that would only be a contested matter that only needed to be served on parties who are represented. And if you have a pro se party, you're still going to have to do the service by mail, but otherwise, that hopefully will be a little bit of a time saver. So I think that should be helpful. Interrogatories to parties. This is another technology issue. And the rule as it was previously written required, as I think was consistent with state law rules, that when you served interrogatories, you left a blank space for the answer. Except that, and then you had to serve an extra copy with the blank space, because then the attorney's secretary was supposed to put it in a manual typewriter and type up the answer, and if it was really long, they'd have to say, see attached, okay? And then you would copy that, and then you would send that back to the other attorney. Well, that doesn't make any sense. So we've revised the rule now, and again, I would like comments if people think this is impractical. But when you serve interrogatories, you just serve them in Word or WordPerfect format, and then it's just very easy for the attorney to take the document and fill it out. Now, you can, and I think a lot of people end up retyping the interrogatories that they're served with so that they can consolidate it all in one document, but it would be nice if everybody showed some professional courtesy and just sent them in Word or WordPerfect. Although then, of course, you do have to watch out for the metadata, and comment if you don't think this is practical. I mean, that's really what it comes down to.
How are you suggesting for service?
Huh?
How are you suggesting for service? Email?
Well, I think email service counts, doesn't it?
I don't know why it wouldn't, but
I think it counts. And so yes, I mean, you need to send it to them electronically. I mean, it doesn't do you any good to send it to them in a hard copy. Send it to them electronically. I think that would work. Anyway, if you see, you are the people that are propounding and responding to discovery. So if you see glitches in this proposal, please tell us about it so we can rectify the rule. There was one other point on it. Oh, something else I just thought I would mention to you. Something that I started doing in practice because my longtime partner, Mike Addison, did it. And we don't have a rule on this yet, but this is just something that I think would make everybody's lives easier, including the court. When you get served with a complaint, okay, what we used to do is we would call the other side and say, hey, will you send it to us in Word? Because then we had one document, we called it our answer. And we would take the allegations of the complaint, put them in italics, or else we'd leave them as is, and we put our responses in bold. Because there's nothing worse than having a long, sometimes I've had cases, 25-page complaints, 30-page complaints, and then I've got a 30-page complaint, and I've got let's just say a 20-page answer. And then you got to go back and forth trying to match up the allegations. What was admitted? What was denied? It's so great if it's just one combined document. So that's just a practice pointer that I would suggest. And it's not, if the complaint's not too long, it's not really too hard to retype it, but there's always a chance for error there. I think the thing to do is call up your opposing counsel that you have a good relationship and say, hey, can you ship me a copy of the complaint? or just cut and paste the allegations of the complaint into a new Word document, and then we'll just answer it all on one page. And I think it makes your practice easier and makes, I know from a judge's perspective, in looking at a lot of these lengthy complaints, makes it a lot easier as well. Okay, judgments by default. This is 7055-2, and this incorporates clerk's office procedures. And it is consistent with the bankruptcy rules and the rules of civil procedure, with one exception that I'll tell you about in a moment. But basically, when you file, you serve a complaint, there's no answer or responsive pleading, nobody's requested an extension of time, and if you want to get your default, what you need to file is your motion for entry of clerk's default. The court will enter the clerk's default, so we have a form document that we enter, so you don't need to submit a clerk's default. Then you also need to submit your motion for judgment by default. That motion needs to be supported by a declaration or affidavit as to the entitlement on the merits of the claim. Under the federal rules of civil procedure, it's not until you get the motion for judgment by default that you get into the need to have a affidavit regarding non-military status. But we think it's cleaner if you deal with that at the clerk's default level, because why get a clerk's default entered and then have to deal with that whole non-military status at the judgment level? Would be better just to get that dealt with up front. And the rule now spells out that you either need a sworn statement of non-military service based upon personal knowledge. So that could be your client's, hey, I know John Doe and he works at Pizza Hut, okay? It has to be somebody who actually knows, which is not the attorney saying, well, I think he's not in the service, okay? Or you can go to the Service Members Civil Relief Act Central Verification Service, and that's where you get a form that they issue. And if you just Google affidavit non-military status, this is the first thing that pops up, and you have to register, and I think you search, and then if you actually need the affidavit, you have to pay a fee like $2 or $5, I don't know what it is, $5, I don't know what it is. But that's really the accurate place to get that. So, if it's something where you're dealing with somebody that your client works with every day, and they know they're not in the military and they're not on active duty, well then that's fine. You can get that person's sworn statement based on personal knowledge. But if it's, particularly when you're dealing with a commercial, an institutional lender, how do they know whether their borrower's on active military service or not? The guy or woman might have, enlisted and be off, in Paris Island somewhere or Afghanistan or something. So that's when they probably would more properly rely upon getting the certification from that website that I just talked about. I think I mentioned this already about the Part 8 rules on appeals being completely revised. And the revision was effective December 1st. And it's a wholesale revision. So if you're working off of a Norton's portable pamphlet or a Collier's little booklet, if you're not working off of the 2015 version and you do any appellate work at all, you need to get rid of your old copies. And what happened was something came up in one of my appeals and it just didn't sound right to me. And I pulled my book and it's like, no, it's not right. And then I thought, oh yeah, I remember they had some revisions December. So I go on Westlaw and I pull up the current revision. And so I'm hoping when we get the new Norton portable pamphlet, I'm really excited because I'm thinking it's going to be like the 2008 amendment, the 2005 BAPSIPA amendments, where they put them all in italics and they kept them in that version through 2008 so that you could figure out what was old and what was new. Well, when I got my new booklet, I realized there's no way they could be an italicized or redline version because the rules are completely different. All the numbering's different. If you have forms that you use in your office relating to appeals, you need to work through them and update them because every single rule number has changed. It's completely reorganized. So we have, of course, a couple of local rules dealing with appeals, and so we've just amended them just to make our numbering system consistent with the big rules. But I I've just seen a number of lawyers filing things in appeals, and they're citing to the wrong rule because the rule doesn't apply anymore, or it's changed significantly. The major rule, the major change is, that really affects everybody, is that you still have 14 days to do your designation of the record and the statement of issues on appeal. But you now have, well, let me back up just a moment. In the olden days, before December 1st, the clerk's office, the bankruptcy court clerk's office, did not transmit the appeal until the record was complete. And then your 14 days to file your appellate brief started running from the day that the appeal was docketed in the district court. Now, the appeal is supposed to be docketed in the district court as soon as it's filed. That is actually much more helpful, and I think it's really helpful when attorneys are filing motions for stay pending appeal. Because as it was, you'd file a motion for a stay pending appeal, but there wasn't an appeal in the district court yet. So they would end up having 2 appeal numbers in the district court. So now the bankruptcy court dockets the appeal, sends the appeal to the district court as soon as it can after the appeal has been, notice of appeal has been filed with the bankruptcy court. The appellant still has 14 days to designate the record and to file the statement of issues on appeal. When the bankruptcy court notifies the district court and ships the record to the district court, that's when the time to file the brief starts running. But it used to be 14 days. Now it's 30 days. So I think somebody woke up and smelled the coffee and realized we had this expedited briefing schedule because bankruptcy appeals are so time sensitive. But then it turned out they're sitting in the district court for a year anyway, so what was the rush? That's number one. Number two, if it was a case of any significance, there were always requests for extension to file the briefs, and they were always granted. So now it's a 30-day appeal, a 30-day period for filing the brief, and a 30-day for the reply, for the answer brief, and I think it's 14 days for the reply brief, I'm not sure. But anyway, you definitely, if you're doing an appeal, go on Westlaw, check the rules, look at your new 2015 books. Do not rely on any of your old books because you'll cite to the wrong rules. And this came up recently on a case, it's a Tampa case, where just so you know, I have beheaded the debtor, just so you know. Anyway, the debtor filed a brief right away. The debtor didn't bother to designate a record or file a statement of issues on appeal, but the debtor filed his brief right away, and the creditor filed a response, and the creditor said, the bankruptcy clerk's office, the bankruptcy court incorrectly sent the appeal to the district court. It's like, no, we correctly sent the appeal to the district court. So you just need to be careful because to me it's just one of those things where you end up with a little mud on your face if you're not citing to the correct rule. It also, I think, is very helpful to the district court because I've seen some district court rulings that come out citing to the wrong rules. So if it were me and I were filing a brief, when I cited to a rule the very first time, I'd put a little footnote as amended December 1st, 2015 or something like that, because if we're a little slow coming to the realization that we've got to be citing to new rules, I can imagine the district court and the district court clerks are, a little bit behind us on that. Although I am told, and it was so funny because, I'm kind of figuring all this out in, early January or late January, and I emailed Leanne Bennett, our clerk of court, something about that. She's like, oh no, we've already had all training with our case managers on the new rules. I'm like, okay, I'm glad. I wish they kept me in the loop for that new training because I wasn't clear about it. Okay, 9001-1 is definitions, and we just added a definition for CMECF, so that's nothing significant. 9004-2 is about, the official title is caption, ... papers general. It just clarifies what the first page of a pleading or a petition or a motion is supposed to look like, and clarifies in paragraph B that it's only appropriate to request one form of relief in a motion, unless the forms of relief are so intertwined or involve the same bankruptcy code section. So it's appropriate to file a motion for relief from stay or in the alternative request for adequate protection. That's perfectly appropriate. It is not appropriate to file a motion for relief from stay or in the alternative to dismiss bankruptcy case for bad faith filing. Those are two completely separate motions, two completely different forms of relief. I think the way the clerk's office is handling them now is that if you incorrectly combine two requests for relief, you get an order that abates one of the requests. So if you file a motion for relief from stay and a motion to dismiss, if you paid the fee on the motion for relief from stay, that one will stand. The motion to dismiss will be abated until you refile a separate motion to dismiss. I think that's how that's being done now. But you just want to maybe take a quick look at that and see how that goes. 9013-1, I already talked to you about this, about the proofs of service in the main case. So you just want to take a look at that and make sure you're familiar with the rules. 9011-4, now this is funny. This is a rule that we had updated a couple of years ago. And it required in the signature block that you include your facsimile number. Greg, this might have been your comment, wasn't it? I think it might have been yours. It included, you had to list a fax machine, if any, but it didn't require you to include your telephone number. Well, who even uses fax machines anymore? Oh, well, all right, then you probably want to include your fax machine number. Okay, but put your telephone number there. Fax number, maybe not quite as important as it was a few years ago.
Judge, I dealt with a lawyer who would not accept email and I had to get a court order directing that he give me his fax number.
Really? Was he a bankruptcy lawyer?
He thought he was.
Well, I think he wasn't. Because I think when you're a CMECF user, I think you consent to service by email.
I was dealing with him in a state court action, and then things didn't go well for his client, and then he filed a bankruptcy on their behalf. Richard remembers this case.
I thought he was talking about me anyway.
No. When we were partners together, we had this. Remember Rodney?
Yes.
Yeah.
Oh, well, maybe. How long ago was that?
Oh,
what's
3,
it?
4 years ago?
Oh,
Yeah,
wow.
4 or 5 years ago.
Yeah. Years ago, people like to get a jump on the 3 days for discovery, and so people like to send them by fax instead of mailing them. And my former partner, he hated it when his fax machine, our fax machine, was tied up with, the receiving a 40-page fax, and not to mention the cost of the toner. So every time something like that got served, he would take the time to hammer out this 2-page letter. I'd be like, will you let it go already? And it always concluded with, you could have just emailed me with it. So anyway, it's just kind of funny. All right, 9016-1, this is a proposed new rule that you want to take a look at. Under Rule 45A4 of the Federal Rules of Civil Procedure, which is incorporated by 9016, you're required to, if you issue a subpoena before trial, so this is like a discovery subpoena. If you issue a discovery subpoena, you're required to serve it on every party to the adversary proceeding or the contested matter prior to actually serving the subpoena on the person who you are subpoenaing. This rule also adds the requirement that you file that subpoena with the court so that other parties have notice that you're doing that discovery. So this was a suggestion by one of the members of the committee, and I've been thinking about that. I've been thinking about it recently because there is that general rule that you don't file discovery items with the court. So, if you did a notice of deposition, you don't have to file that with the court. If you do a any number of discovery items you don't file. We do have a requirement that you file your notice of 2004 exams with the court, and the reason for that is really primarily to protect the debtor from having multiple 2004 examinations by multiple creditors. So this is sort of an exception to that rule, but the thought is in an adversary proceeding, it's kind of nice for everybody who's involved in the adversary proceeding to know, and if it's in the main case, it's just nice to know that a subpoena has been issued. So if anybody has a problem with that, comment. But I think it was just sort of designed to be kind of a full disclosure.
Is the subpoena itself or some sort of notice of
I think you
issuance?
just file the notice of issuance of the subpoena, but if you did a notice of issuance, you could attach a subpoena, right? Because that has all the information anyway, so there's no reason to retype it. Okay, removal and remand, 9027-1. This is a revision. As you all know, when you remove an action from state court, you're required with the notice of removal to file the state court record. And that works out really fine when the action is removed shortly after the complaint is filed, because then the state court record is fairly limited. It's always a little bit of a problem because the state court record is always in reverse chronological order, well, I guess maybe chronological order, but it's always the most recent going down to the bottom, okay? So, and the state court record will also include a lot of extraneous material that nobody cares about. Notices of continuances, just all sorts of extra paper gets in the state court record. So what we are requiring in the rule is that in addition to filing the entire record with the notice of removal, that within 7 days, the party who filed the notice of removal file as separate docket entries the operative pleadings, the substantive rulings, and any pending motions and responses from the state court record on the bankruptcy docket. So I'll give you an example. Some of you are familiar with my Basel Street case, which lingers on today. But anyway, in a second incarnation. But in any event, Basel Street had state court litigation, ugly contested litigation, pending for I think 2.5 years before the case was removed to the bankruptcy court. The docket, I don't even know how big it was, but the record was filed. I asked, it was Steve Leslie at the time, to file an index to the docket, and that turned out to be completely unworkable because you had to go to the index and then it wasn't linked. It was just a nightmare. So, when you get an adversary proceeding that's on the fourth amended complaint, the bankruptcy judge doesn't really need to see original complaint, first amended, second amended, third amended. Bankruptcy judge only needs to see the fourth amended complaint. The fourth amended complaint, the answer, if there's a motion for summary judgment, pending, if there's a response, if there's been some rulings, we need to see that. So as a practical matter, I think it'll make it easier for everybody working in a removed action to have the relevant pleadings just all on the docket where they're easily accessible, and they're each filed as a separate docket entry. So anybody see a problem with that or have any suggestions to how we can make that situation go a little more smoothly, please comment. And then a number of rules are just completely abrogated because they just are not relevant anymore. We presently have, and I'm not going to go through all of them, but we presently have a rule 9033-1 about review of proposed findings of fact and conclusions of law in non-court proceedings. That might be something that becomes more relevant to everyone's practice depending on how the Supreme Court rules in the wellness case. It turned out that our rule really just mirrored the big bankruptcy rules, so we're just eliminating our rule. So you'll have to go to the bankruptcy rules if you want to see how to do that. And then lastly, we have on our Rule 9072-1 under proposed orders, something that Judge Gentleman also referred to at the State of the District speech. In addition to telling you that we had reaffirmation procedures that nobody knew what they were or where they were, she also said there was an accompanying orders list. And I tried to find it on the website. I had kind of a hard time finding it, but it's there. In any event, the rule now reflects that there is a list of what we call accompanying orders, which I do not think is the best title. Maybe we'll come up with a different one. But there's a whole list of types of motions that you do not need to serve on negative notice, that will not be set for hearing, that you can just upload an order when you file the motion. And I don't remember what they are at the moment, but you want to hire an appraiser, just submit an order. There's a lot of things that you want an extension of time to file the debtor's schedules. You don't serve that on negative notice. It doesn't get filed on. It doesn't get set for a hearing. You file the motion. You just upload an order at the same time. And I think Judge Gentleman did mention that we're going to be going to this CMACF system of filing orders. I think that's going to make your lives a whole lot easier. It's not being implemented until, I think, maybe in April, starting one division after another. But I think that'll make your life a whole lot easier because you'll be able to see that your orders have been, are being processed a little bit more clearly, and I think it'll just be easier to track them from your perspective. More importantly, it'll be easier to track them from our perspective. Right now, the system that we use, you know, it's like space-age technology, but we all have a series of folders on our desk, and as I sign an order, I take it from one folder and I move it to another folder. And then, of course, you know, I have a folder of, sometimes I will print out an order because I'm going to mark it up, and then I just put it in a printed folder so I know that it's been printed, and I put a little sticky on it that says printed, and sometimes the reason why. But, you know, I'm always worried, what if I move an order to the wrong folder? You know, what if it just gets lost forever? This way, orders won't get lost. And the other thing is that internally, we can find out if there's a delay in processing an order, where the delay is. Is it at the case manager level? Is it at the law clerk level? Is it at the judge level? We'll be able to figure out what delays are. So I don't think I have much of a problem in terms of processing orders. If any of you ever have what you consider to be delays in processing orders, you know, feel free to email my law clerk or Lisa Mills so that we can kind of look at it. Just so you all know, I do look at every order that comes out of a hearing just because I like to make sure that it says what my ruling was, and it can be hard for my law clerk to make that determination looking at the pro memo that's on the court docket. So I do look at those, and you know, every once in a while I'm tied up in a trial or I'm on vacation or something like that, and those orders sit. If you ever have an order coming out of a hearing and it's important that it get dealt with right away, you know, you just need to contact my chambers, because even if I'm out of the office, they'll email me and say, well, here's this order, you know, can you go ahead and stamp this? Yes?
What if the seating memo is wrong? We had a hearing yesterday that I'm sure you remember.
I do, because it took forever. Why? It was agreed.
The proceeding memo was wrong.
What did it say?
It didn't have the adequate protection that you ordered. It only had the...
Yeah.
So I called Lisa Mills and left the message, but
Yeah.
the proceeding memo was wrong, and I don't know.
Don't worry about
I
it.
don't want it.
Don't worry about it. See, that's the problem.
The order coming back.
No, it won't. Don't, because I'll remember it. And that's
Okay.
all the more reason to get your orders in right after hearings when I do remember it. But I will remember
Yeah,
it, and it's not a
The
problem.
hearing, the order I think is done, but
Yeah.
the proceeding memo.
I mean,
forgot
unless
the-
it's so wrong, like it says something was denied or something was granted when it wasn't denied or it wasn't granted. The proceeding memo is just like a quick little snapshot of what happened. It's not the order. The order always controls, so you don't need to worry about
Yeah,
it.
but I was hoping that nobody forgot the adequate protection. It's kind of.
I would never forget that adequate protection, never. And that's another reason why I always look at the orders, because my law clerk might look at it and go, well, she didn't order any adequate protection, and he might have a problem with it. Okay, then he would bring it to my attention, most likely, but it's like, why should he spend a lot of time looking at it? He can just come to me and I'll look at it. Judge Williamson's J.A. Mary Maddox, for example, she spends an inordinate amount of time listening to the recordings of hearings to make sure that the rulings are correct, and you know, because that's kind of been delegated to her a little bit more.
Right.
And I don't delegate quite as much as other judges do.
I'm
but-
trying to get this to you right away, so you do remember that.
Okay, all right. Well, is it important that it be signed today or tomorrow?
No,
Because it's not going to be.
no, but
And I'm out of town next
important-
week.
It's important that you remember. Yeah.
How could I forget? How could I forget this ex parte communication? Okay. Anyway,
Mea culpa, mea culpa.
that's all right. That's all right. Anybody have any questions for me? Okay. Well, if you can stomach it, take a look on the website and take a look at these rules, and please, you know, share any comments that you have. And we really try to avoid typos, but always a few get through, and we do, you know, there'll be several more proofreadings before they are finalized as local rules. I thank you for your patience.
What's happening with the judge from South Dakota?
Oh, here's our South Dakota judge story, just so you know. The South Dakota's in the 8th Circuit. We're in the 11th Circuit. The 11th Circuit and the 8th Circuit have filed, have signed off on a memorandum of understanding about this position. And at the same time, there's going to be a judge from Iowa going to Detroit. And those two circuits haven't finalized their paperwork. And so there is the goal is to have them both finalized together and the positions advertised together, probably so that the announcements track. But the last I heard from Judge Gentleman was that if the Detroit situation wasn't finalized within the next couple weeks, then the position would be posted. So, and the deal is going to be that it will be a South Dakota judge. South Dakota has 2 authorized judgeships, has never filled more than 1. It'll be a South Dakota judge. The judge will be selected, I think by some 8th Circuit people, but primarily I think the 11th Circuit. 11th Circuit was very concerned about having control over that process. Judge Gentleman will be a non-voting member on the selection committee, which is huge. That's never happened before. And the judge will be for a 14-year term, 5 years committed in the Middle District. It's not contemplated that it would ever be a problem because it's not contemplated. Evidently, people in South Dakota don't file bankruptcy. It's a small population.
The judge's docket, I don't has 80 cases.
80?
Judge Gentleman told me. Yeah.
87.
87, wow,
That's the way you
overworked.
manage.
Man, that's incredible. That's incredible. If it ever approaches, I think the number's 1,200, then the Florida judge could be, yanked back to South Dakota. It's not anticipated that that would ever happen. It's also anticipated that at about the 5-year mark, we might see some retirements here in the Middle District. I think Judge Gentleman is going to retire at 65. I'm sorry, Richard, what'd you say?
Do they have 1,200 people in South Dakota?
I doubt it. It's a small state. It's a small state. Yeah. So anyway, if anybody wanted to apply, I don't think that there's going to be an issue. The judge will sit officially in Orlando. That will be flexible depending on where the judge comes from. It's just that in Orlando is where we have office space and courtroom space, and will be generally available to assist throughout the district. So that's kind of what's contemplated. So, and the other major announcement that will start filtering down, Chuck Kilcoyne is going to retire at the end of this fiscal year.
So that would be August?
September 30th.
Okay.
So, it's like when probably to a certain extent, disregarding when Judge Pasquet passed away, certainly when Judge Pasquet stopped coming down to Fort Myers, and to a certain extent when he took recall status well, now it's 14 years ago, because Judge Williamson is officially Judge Pasquet's replacement. That was an end of an era, and Chuck will be the end of an era. A lot of institutional knowledge, and it's funny because I went home and I told my husband, I said, I have to realize, as long as I've been in Tampa, Chuck has been the man. It's like, you have an issue, you talk to Chuck. So that's going to be a big adjustment for all of our staff. So.
Will you still keep being our judge
Huh?
after the South Dakota judge?
Who knows? I certainly enjoy coming down here. This is a big part of my heart is here in Fort Myers. I think this is a fabulous bar. Crazy cases, as this morning's calendar evidence. And I try to prepare for the crazy cases, and sometimes there's some that come out of the blue. Yes.
Judge, one other issue for practitioners. John Waggy is going to be moving towards a portal to upload your tax returns and pay stubs. He's rolling out a beta test. I'm going to be the person down here that they're going to be the test subject on, but it should be coming out within the next week or two, and we should have something in place, hopefully June or so, if not sooner, because there are some concerns about security and transmitting tax returns.
Okay, and something else I wanted to follow up on. A number of you came up for the Chapter 13 seminar in Tampa a couple of months ago, and we had one of the guys that's with the company that developed the portal for mortgage modification mediations. His name is Igor Reitberg. And during his presentation, he was talking about 2 other portal type things that they have available. And one, I think, was it DocuMods?
DocuMods, yeah.
So they have a program, DocuMods, that will prepare all of the loan modification paperwork for you. And the charge for that wasn't too much. And then they have another program called something else that I think costs $200 that would coordinate with your clients in having your clients get all of their paperwork put together. And that seemed to me to be something that would really be interesting if you could, if you look at the $1,800 flat fee, or reasonably, what do we call that? Presumptively reasonable, thank you, Greg. Presumptively reasonable fee for doing a mortgage modification mediation. Probably a lot of that is a lot of attorney and clerical time at your office in helping the debtors assemble all this documentation. You could offload that for $200. I think that $200 would come out of the $1,800, but I think it'd probably be cheap at twice the price, frankly. Igor would really like the judges to make it mandatory. There are evidently some jurisdictions that have at least the DocuMod portion of it being mandatory. And he says that the percentage of successful mediations in those jurisdictions is higher than other jurisdictions. Our judges have a real problem in endorsing any commercial activity, and I think that's why the mortgage modification mediation administrative order now doesn't designate that portal. It talks about using a portal, but not particularly Igor Reitberg's company's portal. But I think that's something that those of you who do mortgage modification mediation might want to look at a little bit, because the DocuMod system sounds great, and the whatever this other program is that will work with your clients to getting all their documents put together, really sounds great to me. So that's something probably to keep in mind. And that's something that I am going to talk with the Chapter 13 trustees about. I don't think they have quite the compunction for mentioning companies by name that maybe the court does. So they might be able to make that available. Okay, and thanks to those of you who came up for the ABI Pass Case Seminar last week or so ago. That was, I think, pretty successful. It was always nice to see a group from Fort Myers. Okay, thanks.
Just quick, before everybody leaves, May 21st, try and be here. We're going to have Larry Hankel do a presentation on dischargeability of tax debt. That should be pretty interesting.